Hi, I'm James Minick, and today we're going to talk about the defenses of automatism and involuntary intoxication in the context of a DWI charge. These situations can oftentimes feel like a law school exam fact pattern when you get into a situation where a person claims that they basically committed the act while they were unconscious or were not aware of what they were doing. These two defenses are closely connected but slightly different. Automatism would really be a situation where the person is in a state of mind, though capable of action, that they are not conscious of what they're doing at the time of the alleged crime. And this would be kind of the sleepwalking, or a lot of times in a DWI context, the drug that is at issue is Ambien. This would be kind of a sleepwalking defense, where a person is doing things that appear outwardly conscious but is not conscious and not doing anything with any mental state of culpability. The other defense, involuntary intoxication, would be a state of mind in which the person is conscious of what he's doing. So conscious that maybe they're drinking something, or conscious that they have consumed something into their body, but unaware that their faculties have become appreciably impaired by the foreign substance. So a person that has unwittingly been drinking spiked fruit punch, or a person that is given the wrong prescription medication, and the prescription that is the medication that is given them has impairing effects that they were not informed about or aware of. Those would be the differences between an involuntary intoxication and automatism defense. In terms of the elements for each of these defenses, for a defendant to earn an instruction on the automatism defense, the defendant needs to prove that his actions which led to driving began in a state of unconsciousness. On the other side, to earn an instruction on the involuntary intoxication defense, the defendant needs to prove that he was not aware that he was consuming an impairing substance. Really, in regards to these defenses, a big question, and something that might even bar the defense, would be an admission by the defendant that impairing substances were voluntarily consumed. And so that would be something to kind of look into in terms of factual situation about how it was that an impairing substance entered your client's body. The burden of proving both of these defendants is on the defendant to the jury's satisfaction. Remind the jury that this is not a burden of beyond reasonable doubt, but only to their satisfaction. The notice as to these defenses is required potentially on a felony variety of DWI under 15A-905 C1. I would argue that there is no notice required where the original jurisdiction of the charge lies with the district court. So on a misdemeanor DWI, I'd argue that notice of these defenses would not be required. It may be best to be on the safe side and actually provide notice either way, but I think there would be an argument on appeal to Superior Court from a misdemeanor DWI that there was no notice required to be given to the state as to intent to argue these type of defenses. There is a pattern jury instruction on automatism, or the statute, or the pattern jury instruction also refers to as unconsciousness. There does not appear to be any similar pattern jury instruction for the defense of involuntary intoxication, and so we've actually tried to craft in our blog article on this topic a pattern jury instruction, or not a pattern jury instruction, a jury instruction on the defense of involuntary intoxication. Look at the instruction for automatism in terms of knowing what it is that the judge is going to tell the jury that you have to prove before you ever step foot in the courtroom the first time. Always refer to the pattern jury instructions early on in terms of what is it that is to be expected of you in terms of the legal requirements for showcasing the defense, and in terms of the jury instruction on involuntary intoxication, because there is no pattern jury instruction. If you have prepared a well-organized written instruction for the judge to look at, a judge very often may accept that instruction verbatim where there's no pattern jury instruction. That would require him crafting that on his own. So make sure the instruction is an accurate reflection of the law, but being the drafter of the requested jury instruction does give some power in terms of how that instruction might be perceived. More information is available on our blog on this topic, so please go there for further legal analysis of these particular defenses.